Good afternoon, everyone. My name is Susan Farbstein. I'm a clinical professor here at the law school and the director of the International Human Rights Clinic. And on behalf of the clinic, it really is a privilege to welcome Judge Navi Pillay back to Harvard Law School. For anyone who works in the realm of human rights, she needs no introduction at all, but I will try to briefly say a few things about her absolutely exceptional career. Judge Pillay grew up in apartheid-era South Africa. She experienced all the racism, discrimination, and exclusion inherent in that system. As a student in the early 1960s at the University of Natal, she was involved in conversations and activities to protest, to boycott, and to end the apartheid regime. After earning her law degree, she spent decades defending anti-apartheid activists, exposing the use of torture against opponents of the apartheid regime, working to secure basic rights for prisoners held at Robben Island. During that time, she also became the first non-white woman to open her own law practice in her home province of Natal. She also became, in 1988, the first South African of any gender to earn an SJD from this law school. In January 1995, after South Africa's democratic transition, she was appointed to be the first non-white woman to serve as a judge on South Africa's High Court. She served only briefly there, however, because she was soon elected by the UN General Assembly to serve as a judge at the International Criminal Tribunal for Rwanda. She spent 8 years there, including 4 years as president, and is perhaps best known for her time there for her ruling in the Akayesu case, really a landmark decision that recognized that rape and sexual violence could constitute acts of genocide. In 2003, she was elected by the UN to serve as a judge on the International Criminal Court, a post that she left in 2008 when she became the UN High Commissioner for Human Rights. And that was a post that she held until 2014. I think in that position, it's fair to say that she built a legacy of addressing all forms of discrimination, including against previously overlooked groups, and highlighting the importance not just of civil and political rights, but also economic, social, and cultural rights. So she's an icon, she's a role model, and it's just an honor to be able to have this conversation with you today. I think we'll start with the UDHR because it will turn 75 years old next year. And since it was created, we know that there have been lots of new human rights treaties, new human rights organizations have proliferated, new institutions have been created to monitor and enforce human rights. The UDHR has been at the foundation of so much of that work, but I'm curious how and where you think the UDHR has had the greatest impact.
Well, thank you for that introduction. So always remember, I was a student, and you know, when you get your first degree, yes, I was the first in that whole community, slum community, to get a degree. So when you do, and you see the graduation procession with yellow gowns, red gowns, and so on. And you're so proud you got your first degree, and then you're in awe. When am I ever going to get all those other degrees? So I'm starting off by saying I was a student, and you work hard from day to day. It's only when you look back, then you think, oh, did I do all that? Meaning the opportunities and powers that I had, and I could make that difference. But above all, it comes with education if you want to address things that have not been addressed before. So my South African experience helped me because we very actively fought apartheid, but in the courts. People always said you're wasting your time in the courts, but we use the mechanisms that we know of, and rule of law is still a very strong principle to hold up to. So you asked me the most profound impact I know of UDHR. So there we were in South Africa under racism, institutionalized racism for 300 years. And as I studied and came here, I realized we don't have a standard to compare our apartheid laws. How do we argue it's wrong? Compare it with what? And that's the importance of having a universalized standard of human rights norms. And this is what UDHR did for us. We learned very slowly, by the way, to use the language of UDHR and to speak in terms of human rights, because we were trained under the common law, and we used the common law. For instance, I brought an application that was of great help to President Mandela and my clients who were on Robben Island prison. And I used common law to approach the courts. My clients asked me to do that because they didn't know what's their rights in prison. They're being treated like property. One of them, who was a lawyer, handed in a petition to the officer commanding, asking can they teach English to the Transkeians, and can they have the rules, the prison regulations, for which he was sentenced to 6 months imprisonment on spare diet. So when I went, he was brought separately from detention. Now, we're not supposed to talk about any of this in the prison. I'm there to consult them on legal matters. So I'll leave it to you to imagine how we communicated. And they were able to share with me the immediate challenges. And they also informed me that, well, he wasn't president then, but Nelson Mandela was against any kind of court action. He wanted to negotiate because under the apartheid system, you're not likely to get any relief on rights. And if we fail, that will bring the ceiling down. Yeah, I was like 32 or 35. I go out from there, but I consulted people. Very important to get the opinions of experts, other lawyers, really top advocates whom I didn't know. I just tapped on their door. And they all said to me, go for it. And so we ended up with an order ordering the prison authorities to provide the rules and regulations to the inmates so they will know what they can do and not. And spelled out that they had a right to a lawyer. Nobody had a lawyer going there before that. And they spelled out that if there was a violation, alleged violation of prison regulation, there has to be a trial, not justice, because they had no power to extend the punishment already. So this was like in 1973 or something. What they were not allowed to do is study law, because that's a privilege. But they had the right to smoke. So we got a mixed bag of relief. But the big picture is that they then had right to lawyers, they could get law books, they could study, and they told me it changed their lives. They were able to handle imprisonment. So we didn't use the UDHR. Now I know that we should have. But courts were not receptive to international law at that stage, as is your Supreme Court here in the US. So common law helped us. And then, the media reported that the curtain has been lifted on Robben Island prison for the very first time. And what we established there was applied even to whether prisoners have a right to vote. In my country, they do now because of that decision. You don't have it, yes. So what I'm saying is you start on one little thing bravely, hoping for the best, and you're not just hoping, you do the research and present proper arguments. Otherwise you are. Mandela would have then been right if we had lost. And the other effort I made for the very first time is to check on torture. My husband was in detention, so I brought an application against the security police not to use unlawful methods of interrogation. I put the affidavits of the 10 others who were charged and who had been brutally tortured by this one man who's the head of security. And so they were furious with me because they said, we police do not torture. But we successfully got the interdict, and my husband said he just wept when he got this order. The sheriff threw the order at him. Now, what happened with that? A few years later, Stephen Biko was killed under torture, and the ANC anti-apartheid movement approached the UN for sanctions. Ronald Reagan and the British UK Prime Minister vetoed that for sanctions against apartheid South Africa. But the UN also asked for protection against torture. And that's how they started the Convention Against Torture. And I didn't get my husband out, but look at the end result. And the UN was able to do that because of those affidavits setting them out. So a long answer to why we need universalized standards so that countries won't say this is the way we do things. Yeah?
That's great. So,
Yeah.
Sorry, go ahead.
And also the UDHR is the basis of core human rights treaties. People flesh this out to come up with the Convention on Civil and Political Rights and Economic and Social Rights.
Wonderful. So you've given us a really powerful example of the importance of universal rights during the apartheid era. I feel like critics of human rights often say that now human rights is sort of outdated, or it's ineffective, or it's irrelevant to meet sort of the challenges of this era. So I'm wondering why you think the Universal Declaration still matters now in 2022, almost 2023.
I would say the UDHR is much broader than even the human rights movement that it sparks. So it is a comprehensive vision that is relevant today as in 1948. Because I saw through my career as High Commissioner for Human Rights, firstly, two representatives from the State Department here met me early days. I was just elected, and they said, there's no such thing as a right to health. Don't go there. Yeah, well, you didn't get health insurance, yes, so that's, and I had to tell them, you don't come and tell me what to do. And then I went to Margaret Chan, who headed WHO, and spoke in terms of right to health. And she said, oh, she got into such trouble for mentioning it as a right. So everything I did for 6 years was a challenge. And what's the basis I look to? Is the UDHR. It's true, I know you're going to ask me shortcomings of the UDHR, but you pick the ones that help you immediately. So health is recognized as a human right now. Right to development, there's a minister in Germany whom I was talking to, and she said, don't even go there. There's no such thing as right to development. Development is something that develops from the ground up. So you can't impose it from the top. So we have right to development. And one of the things that I'd worked on is if you look at the Millennium Development Goals on development, those state parties absolutely objected to two words being put there, human rights. Just didn't want human rights there. And so you had goals. They would save 50,000 people from maternal mortality. What about the rest? It left many questions, but it was a first step. When I came in, we were working on the 2030 development mandate, and you'll see human rights in 8 places there. It was such a struggle to push that language, not me so much as my team of experts in the office. So it's very relevant even today to have these, and it's fleshed out, as I said, in many treaties, conventions, and committees. So I just met someone who's a member of the Committee on the Rights of the Child. they produce authoritative jurisprudence expanding these rights. So, you know, as a judge, I followed in South Africa and elsewhere that we, the judges, decided what's in the best interests of the child. We never asked the child. Yeah, but now you have a convention on the rights of the child. Yeah, you have to have a legal representative for the child. Or if the child is old enough, courts should speak to the child. So that's a little difference on developing what's here. The committees are very important. Children can now bring complaints to the committee. It shocked parents. That's been adopted as well. I would encourage you to look at all the human rights mechanisms. That's the treaty body committees, the almost 60 special rapporteurs. These are independent experts. And of course, the Office of the High Commissioner for Human Rights. But my chat with Margaret Chan, the head of WHO, ended with her throwing me out of the office because she said she's controlled by her board. So I said, can we have working teams from my office and your office working on this? And lo and behold, in a few years, she was talking in terms of health as a human right. So I'm saying to you, we have, whatever we have, UDHR, let's develop that. These are small steps, but they grow into big steps. And there's so many more rights. They're waiting for you to flesh these out and to activate them and get states to undertake them as obligations, not as charity that they're handing down. You take the people with disabilities. That's what they resented, that they have rights and they are not there to be told the state is doing a charitable act for you by providing you with this and that. So now they speak for themselves as a treaty body for persons with disabilities.
Wonderful. So I think next I want to ask you a question about the practice of human rights. So sort of the work of human rights advocates, lawyers, practitioners, because the movement has evolved and adapted in so many ways over the last 75 years. If we think about the strategies that are used, if we think about the communities that are engaged, if we think about the voices that are represented. And I'm wondering, from your perspective, what you think the biggest change has been in the work of advancing human rights, sort of the strategies, the tactics, the tools, the approaches that advocates take today?
When I sat on that Akiyesu case and heard the women testifying about mass rapes, saw that it wasn't charged in the charge sheet, and then asked many questions. So three judges, gave a clear indication to the prosecutor that we want to take this seriously. And so then the prosecutor amended the indictment and so on. So what has Akiyesu done now? It set standards. The very first conviction on war crimes, sexual violence of women. We had to spell out a definition because there was no internationally accepted definition. So I would say that that's one of the relevance of UDHR. It's true, it's what we have. We can criticize the document. Now, when I started as High Commissioner for Human Rights in 2008, I found that the office would write an op-ed, beg New York Times to publish it. They may or may not accept it. If they do, it'll appear on page 13 or something. And you wonder, now who reads this? So lucky for me, social media started when I was High Commissioner. So so the colleagues would say, look at the statement you made this morning has now been seen, or I don't think Twitter was on then, but 2 million people have seen that. And that's why we call it really like a golden era of human rights, where we're able to use the tools. Out there is civil society waiting for academics and for us to frame the arguments. right? Because they're very helpful. They haven't, I mean, they're very helpless. They don't have the tools to articulate what it is they want. NGOs in Africa said to me, of course, it's okay that the international NGOs speak for us, but we don't want that. We want to speak for ourselves. And can you help to have training arranged for us so they could speak for themselves? So some of it is the language, how you frame these challenges. And I think most of you are studying law. We have such an important contribution to make. When things were changing in my country, so I'm talking about 1992 when Mandela was let out, it's the women who got together first. Of course, it was endless fighting amongst us, me too. But, but I discovered that people hate lawyers. They said it to our faces. And I'm guilty of that. We were so imperious, we thought we could, this is what, you have to be arguing about equity or equality. And then we did a questionnaire on the street, supermarkets, so on. And back we heard from all women. Yeah, they wanted economic rights. They wanted education for their children, and jobs, and equal pay, end to poverty. So that's what we embraced in that document. And so we have a wonderful constitution, and we have a Bill of Rights. It's a women who contributed to that Bill of Rights. And where did we get it from? Eventually, from people on the street. And we as lawyers had to learn to respect the opinions of everybody. You know, we left contentious issues such as abortion and multiple marriages and so on, yes. It was very contentious in the context of South Africa. The women wanted polygamy. They said they feel it's worse for us women who are faithful to our husbands, that we have to please him all the time. It's much better if he has 3 or 4 wives. You see, as lawyers, we have to put up with arguments like that. But the end result is we got a very good document. So back to the High Commissioner position, we were very fortunate. There are almost 1,000 staff, highly committed, highly qualified people. You know, to be an intern there, you need to be registered for your master's. It's really, sorry about that, yeah. Stakes are going up and up for you. So everybody makes a contribution. There are discussions, and they draw these documents. And so in the UN, it became known that the best writers are in OHCHR, the Office of the High Commission. So whatever I say that we produced in my 6 years, it came from colleagues. And they were always addressing new issues that had not been addressed before. Do you remember when the German Chancellor, Angela Merkel, and the Brazilian president, the last one, I forgot her name, yeah. Yeah. So they both complained about surveillance on their cell phones, done here, of course, in this country. So they complained to the General Assembly, and then I read in the newspaper, they asked the High Commissioner for Human Rights to prepare a report on the right to privacy. And so that was new. It had not been done before. Social media had just started. We all like to use social media, but then comes the drawbacks. So how do we prepare a report that is authoritative? And we're doing the same now because I chair the Commission of Inquiry into Israel and Palestine, and my 3 colleagues are here helping us every step of the way. We are 3 commissioners. So we consult experts, students, civil society, human rights activists. We draw on all that, and we have a lot of information, for instance, now on the Palestine question. So that's what we got on the right to privacy and so on. So that's a GA document, and it's being improved every year as things get more and more complex on social media. So these are some of the things that We did, from a document adopted 75 years ago with a wonderful role played by Eleanor Roosevelt. We owe that document to her because she really pushed for human rights. Human rights was always considered a soft issue, and that's what I found. My first meeting, I'm sitting in what is called the CEB, the Secretary General calls all the heads of agencies, including those who are not part of UN, such as IMF, World Bank. And for 5 hours, I sat there. Nobody mentioned human rights. And I was too timid, just new there as High Commissioner. So eventually I found my voice and I said to the Secretary General, you're going to go out there and address the press and not mention human rights? Yeah, you're going to get criticized for that. You know, some people care about whether they look nice or whether they criticize. And that's how the language got into that. So inside the UN, it's a big struggle. To get human rights mentioned 8 times in the development program was also the work of human rights activists. So, and we can only do that if we act collectively. Your contributions, for the rape definition, for deciding what are the elements of crime for genocide. We had to do this for the first time. None of the judges had studied international law. So we got the help of academics. I often hear academics saying, you know, we don't know whether we're wasting our time publishing. I know you're obliged to publish articles here. And they said, we don't know who reads this. And I said, we read it. We practitioners read them. So I'm going all over the show with your questions. No. Sorry about that.
It's wonderful. I might, we've been sort of backward looking. I might ask you a forward looking question, because I think when people in the field look forward today, I feel like there are a couple of big crises that tend to be discussed. Climate change comes up a lot. Social and economic inequality comes up a lot, and I think the decline of democratic norms and institutions. So I'm curious, as you look forward for the next 75 years, what do you see as the biggest threats to human rights? Where should we be focusing our time and energy?
Well, I and the other human rights commissioners, including Zayed, who just followed me, have said publicly that the biggest violators of human rights are states. So I stay with that. They draw all this framework. They undertake obligations, but they do not exercise any political will in implementing them. I came here to raise, I'm on the Death Penalty Commission too. And I raised the issue here with governors that still have death penalty. So they all feel very badly about it. It breaks their heart to sign that death penalty warrant. Yeah. So why don't you change it? Oh, it's an election issue. So I say we have very good framework. We really don't need newer and newer frameworks. We do on social media now, of course. But you need activists. So I'm really sorry, I addressed universities here during the Trump era, and students were very despondent on this, especially when we added to their burden by saying, oh, the only chance is for civil society to become more active. Why should the burden be placed on civil society? So take it as a challenge. If our governments are not complying, we have to speak up about this. So I've seen, obviously, tremendous changes in my lifetime. And I owe it to the standard setting, a universalized standard setting that's done here. But there are many impossible situations. I think I went to Cameroon, and I said that they're parties to the Convention on the Rights of the Child, which has an age limit, 18, for marriages, doesn't allow forced marriages. So I asked the minister, what are you doing about that? I heard that you'd passed a civil code, which now complies with the Convention on the Rights of the Child. And I said, I hear that it's like 9 years since Parliament adopted it, but the president hasn't signed it. And she said, no, that's not true. It's 19 years since it's sitting with the president and he hasn't signed it. So think of the populations there, how much harder it is for them to carry out these battles in the face of oppressive governments. What those students and activists look out for is what you are writing and what you are saying.
Wonderful. I'm mindful of the time. I want to save time for student questions, but I have a few more myself first, if that's all right. I think one is a question about being a first, because you have been a first many times over, as I spoke about when I introduced you, first woman of color to open your own law practice, first South African to earn a degree from this law school, first female judge at the ICTR, first panel of judges at the ICC, lots and lots of firsts. So I'm wondering what advice you would have for other folks in this room who might be firsts in their own way, or if not first, perhaps they're outsiders in the law in some way, if you have any words of wisdom.
The people will criticize you, people will pull you down all the time. I had no choice but to start my own law practice because no law firm would take me on. You know, I'm always quoted on what I say. I was discriminated on 3 grounds. 1, I'm a woman, what if you fall pregnant? And 2, well, is your father a businessman? Will you be bringing work in? And you're a black person, and we can't have our white secretaries taking dictation from a black person. So you see, race, class, gender. So really, I had no choice. People thought I had a lot of courage in starting it. But you know what some of the male lawyers said? They said, you're very presumptuous in starting a law firm, right? Women can't manage law firms. I think we all look for a way out when you're facing a wall. You're going to get the criticism. You have to face it as I'm facing now for being on this commission on Israel. So I still say the same words. You know, I feel confident. I'm on the moral high ground here. But the beauty is so many other women started law practices after that. So that's one of the firsts. The other first, you know, they just happened. I didn't apply for any job. We had just got our democracy, and we all wanted to play a role in South Africa. Can you imagine? All my life, apartheid. Now we have freedom. And President Mandela made me the first woman of color to be a judge, but it was an acting position. The Advocate Society, the Bar Council, composed of white men, called an urgent meeting. Agenda item, Pillay, competence of Pillay. Because I was an attorney, not an advocate. And so they resolved that they'll monitor me as a judge. You know, I was 30 years as a lawyer, so I could slip in and be a judge. I knew the law. Inside there were apartheid-era judges, white, English, and Afrikaans. And the 2 groups just didn't meet for tea or anything. They had sipped tea times. And both invited me to join their groups, which was such a revelation to me. Race fell off, yeah. So what did those judges tell me? You just ignore that. They hated the notion of the Bar Council monitoring a judge. So that was their principle. So I had them on my side. And actually, they were very helpful to me. You really need help when you're just starting on anything. And then I was nominated by the president again to the Rwanda Tribunal and elected at the General Assembly. So all knew it meant leaving home. I looked on the map and thought, all right, so Arusha is like that far from Durban, so I can come home all the time. And I had to be persuaded by the women's movement here, actually, to take up that position, because they said, if you don't, we won't have a woman on the bench. And it turned out, yeah, I was the only woman for the first 4 years. And so I went there thinking, okay, I'll serve for 1 year, and I'll step out, come back home. 8.5 years later, there I was, And the conditions were a real challenge. It's really a rural area. There was no supermarket, no pasteurized milk, and the bishop's wife offered to give me some milk from her cows. I come from a big city. So there were all those challenges, but above all, no library, no legal assistance. It was really crazy. And so I saw the immediate hardships and thought I will go home after a year, until I heard the witnesses. And they said, we waited for this day to see justice being done. They'd lost, if you ask them how many members of your family died in the genocide, they will say 400. Because it's a village system. They were a community and they were family. So huge losses and the rape and sexual violence. And so in all conscience, I thought, I'm really privileged. What am I complaining about? So that's how the first developed. What I didn't want to do is resign as a judge of the ICC, but the Secretary General interviewed me and said, no, we want you now because of the review conference of the Durban Conference on Racism. I don't know if you followed that. The original conference was held in Durban. Mary Robinson was the High Commissioner for Human Rights. I was not there, I was in Arusha. And this is where Colin Powell led the US delegation and walked out. They were so cross with the Arabs. The foreign minister of Israel put on his website that Durban conference was a success for them. And then for the next 8 years, they built this huge propaganda that it was anti-Israel. And the Israelis were so hurt by that conference. And how did it react here? That group in the UN refused funding for the review conference. Nobody wanted to touch the review conference. And the Secretary General told me that every year, the budget only gets passed on the day before Christmas, because the US held up that budget. They opposed that review conference. And so he wanted me to resign. And to me, I did the unbelievable, resigned as a judge. I knew zilch about the High Commissioner's office and UN politics. So within months, I get a call from the Deputy US Ambassador here in New York, because they were debating the budget. And he said, look, we can get Israel not to oppose the budget if you are prepared to withdraw the word Durban from the Durban Declaration on Racism. And I said, how about the Vienna Declaration? Shall I remove the word Vienna? So both phones went down dead, and they passed the budget. So all I'm saying is, you may be the first, but if you have the power and the opportunity, you are letting down people if you don't use that. So any sexual language or harassment or gender discrimination, the interpreters would say, Judge Pillay will pick that up. So we had written a draft letter to the Security Council, and the Russian judge said, oh, that letter is so weak, it's like women's talk. And I said, just a minute, can you explain that, what you mean? And he said, oh, I'm sorry. And yet I could have kept quiet, because I didn't have you guys judging me there. I could have kept quiet, because sometimes it's so difficult to intervene. You have to intervene and speak up.
I'm going to take the liberty of asking one more question, and then we'll open it up to the floor. So another famous graduate of this law school, Brian Stevenson, has said, the enemy of justice is not injustice, it's hopelessness. And you've been doing this work for a very long time in so many different contexts. I find that students at the start of their careers often ask us some version of, how do you stay strong? How do you build resilience? How do you persevere in what can be a very difficult field of work? So I wanted to ask you that question. How do you cultivate hope? What gives you hope?
I suppose I've seen successes. I gave you some idea of small initiatives leading to some big result. We got 8 places of mention of human rights in that document. Oh, that took like 2 or 3 years of persistence. So don't be put off by detractors. Let me tell you another story. And in this case, it happened to be about interns. So people like you, if you're just bottom of the ladder in this hierarchy of the UN, not paid and just servicing. So there were a couple of interns in South Sudan, in that Blue Nile area, which is only accessible by UN helicopter. And so they wanted me to come there. I had meetings with the president and vice president who were fighting. People were being killed. And after dealing with that, we did get onto the helicopter and go to this area where the River Nile floods the whole place. It was really damp, muddy. And under the trees, these interns had gathered like 12 women, and they were from different tribes, and they spoke different languages, so they didn't understand each other. And as I looked around, I found some of the women had all their front teeth missing. So that's the trademark that tribe uses to mark their women as property. And others had all these gashes on their face. And this is the first time they're meeting a high commissioner, and they're speaking about what troubles them most. And I recall 2 of the women saying that their husbands and sons killed their daughters, 13 or 14-year-old daughters, because the father had arranged marriages for those girls. This is 2 households, to, of course, elderly men who owned cattle. So it was really trading the women for cattle. And they said, when the girls refused, they were killed. And these women are telling me, and we know where they're buried, in our backyard. We told the police, but nobody's doing anything. Don't we have rights? We gave birth to these girls. Don't we have any rights? So I repeated just the most simple, basic things and encouraged them. But as I walked away, I felt that hopelessness. And look how far this is from, we're a planet away in terms of spelling out human rights. And how we're going to ever reach communities like this, we're just stuck. So a month later, the ambassador of South Sudan came to see me with a big smile on his face. And he said, something has happened which has never happened before. You know, the women you spoke to under the trees, they gathered together and they went to see the governor and said, we want our rights. So do motivate people, but what you think is just straightforward, simple, and you know it, you've lived it, other people don't know. So all we said to them, I definitely felt that was a hopeless situation. It's not going to change. But it did, because the women were encouraged to do something about it.
Wonderful.
Right? So who said that about hopelessness?
Brian Stevenson, who
All
runs
right.
the
Tell him.
Equal Justice Initiative.
Yeah. Yeah, I wouldn't say it's hopeless. It's shocking. It's astounding that in this day and age it still carries on, the violations. And by our governments. We're dealing with corruption in my country. These are former freedom fighters, and they've looted all the state assets. They're not state assets, they're taxpayers' assets, in huge amounts. But at least there are public inquiries and prosecution. So not so hopeless, but I agree, there are many challenges.
Wonderful. All right, so why don't we pause here and just say thank you so much. Thank you.
Thank you very much.
We've managed to save about 15 minutes for questions, and I believe we have a couple of microphones. So if anyone has a question for Judge Pillay, just raise a hand, and Marie can bring around the microphone.
Hi, thank you so much for speaking to us today. My question is, I think one of the big shifts that has happened over time with human rights is that everyone feels they need to use the language of human rights now. Even governments, they can't explicitly say they are ignoring it. They tend to use it in that language. So my question is, how do we stay vigilant about the abuse of the terminology of human rights to promote like authoritarian projects or things like that? Just as an illustration, in Sri Lanka, which is where I'm from, we're a dualist country, so we have an ICCPR Act. And the provision in that act which speaks against, which enacts the prohibition against racial hatred or advocating racial hatred, is only ever deployed against minority actors who speak out and upset the sensibilities of majorities. So how do we stay vigilant and guard against that?
You know, I agree with you by abusers now using the human rights rhetoric. Sometimes they articulate it better than us. Meanwhile, they are the violators and perpetrators. Yeah, no, I agree with you. I've seen so many of that. You know, I've been to Sri Lanka. And more recently, where was I? We were talking about protection of minorities. So that's absent in UDHR, isn't it? These are individual rights. They're not group rights. The African Union's charter provides for community rights. So this was drawn in 1948. There's no group rights here. And you and I may feel uncomfortable with group rights anyway. We want individual rights. But in Africa, they think in terms of community. And then, assuming there's an identifiable minority, there's all kinds of violations against them. They need to be protected. So the ordinary laws of Sri Lanka can be used even for the protection of minorities. In practice, it's really difficult to address discrimination and so on of minority groups. And let me assure you, it's a regular item on the agenda of the High Commissioner for Human Rights on the protection of minorities.
Wonderful, and I think I saw it here.
I can be loud. So it seems as if the people who are most convinced by human rights are human rights advocates themselves, and that includes judges at the ICC, students who study human rights, lawyers, advocates, civil society activists, etc. And so I've been asked this question a lot by people who are either skeptical of the universality of human rights. I've been asked questions like, don't you think human rights is dead? Why should civil society fund human rights organizations? Because like you said, it is the states that are the biggest violators of human rights. So how do you convince states, especially populist regimes or authoritarian regimes, to respect the language of human rights? Because of course they have obligations under the ICCPR, the UDHR, etc. You can probably take them to court, but who's actually going to do this? And how do you advocate for human rights with non-believers or people who are skeptical?
Just look at all the mechanisms have been developed just in the last 20 years. We never had an International Criminal Court for accountability. Now we have it. All that didn't come overnight because politicians thought of them. They happened because of pressure from civil society. So there is hope there on how we can use the UDHR and other treaties to expand human rights protection. You know, I mean, I can give you several examples where we address this issue. And when I became High Commissioner, I realized with the shock, Durban, my city, is a bad word. Human rights is a bad word. Nobody wanted to mention it. I was together with all the UN heads, and guess who was there also is Guterres, Antonio Guterres, the current Secretary General, who was then the Under Secretary General for Refugees. I was for Human Rights. And then we had OCHA, the food program, and four of us. And so as I joined them, I realized they're talking about a planned visit to President Obama to ask for funding. And I said, oh, can I come too? Can I join you at that meeting? And Guterres said, oh, no, we'll lock you up far away somewhere. We'll keep you out of that room. Yeah, he's Secretary General now. Yeah, I said, okay, I'm just sharing that with you, yeah. So that's the attitude to human rights, that it's troublesome. And one ambassador from a powerful country in the East told me that it's gone too far, all these human rights mechanisms and protections and the High Commissioner's office. and UPR, which is a scrutiny of the human rights record of every state. So he told me we never intended this. But we're still there today, no matter what opposition, whichever way the veto goes.
Wonderful. I think I saw a hand back there and then up here.
Hi, thanks so much for talking to us today about your wonderful experiences. I'm just wondering how your role as an international criminal law judge squares off with your previous role as a lifetime human rights advocate, because I see the impulses in the two slightly differently. International criminal law's impulse to criminalize is different from human rights' impulses, in that international criminal law pins responsibility on one individual as though conflicts arise because of individual deviation or bad morality. I'm sort of seeing, I sort of see that tension played out in your Akayesu judgment, in that the definition of rape as being linked to coercion rather than consent is celebrated worldwide by human rights advocates. But a strict criminal lawyer would suggest that the principle of nulla pena sine lege would be applicable, and it's sort of uncomfortable with the suggestion that a judge could, or that a tribunal could craft a definition of rape and then convict people on that basis, sort of retrospectively. So I'm wondering how you see whether you see the conflicts in the two roles between an international criminal law judge and human rights, and whether the impulses towards both are the same or different.
We need all three, international humanitarian law, international human rights law, and international criminal law. We need criminal law for accountability. Victims want to see the perpetrator punished, so we need that. How do judges jump into interpreting it in a human rights way? Yes, so I was criticized for that. What do they call us? Something criticized here in the US, that we're supposed to stay within the four corners of the criminal law and not go out of that. If we don't have a human rights perspective, then we will be tolerating all kinds of injustices. The South African Constitutional Court was presented with a case where a little boy had been molested, raped, but the sentence, if it had been a girl child, was much higher than if it was a boy child. So the lower court sent it up to the Constitutional Court, and Richard Goldstone was on that court, and they used Akayesu's gender-neutral definition. So if you didn't bring in the human rights aspect, there's injustice there on the ground for child victims, for men they were raped in large numbers, men and boys in Yugoslavia, and the Yugoslav tribunal had first charged sodomy, sexual violence, because there was no internationally accepted definition, which is gender neutral. So they adopted that definition, changed that charge sheet, and the Rome Statute has it, but they threw everything in, including the kitchen sink, in that definition. Yeah, so it's really mixed up. So I don't know if I'm addressing your question. It's all complementary. And I've spoken to many judges. You have to have empathy because you're rendering justice. But we are criticized for making law. Some judges do that. Some judges very faithful to what has been done already. But you could see the huge improvement. I was told by judges in India that they followed our decision on AIDS, because the court ruled that you remember we had a president in Mbeki who said you'll recover from AIDS if you eat beetroot. And this was at a world conference. And so he refused to allow doctors to dispense medication. So that judgment was so useful in India and Malaysia, lawyers told me. So we're getting there slowly.
I think we have time for one more question.
Thank you so much. I was just wondering whether you think there's opportunities to provide, or what kind of justice mechanisms can be used in countries where there's been political continuity, because in a lot of transitional justice situations, we're dealing with situations where there has been transition, whether that's Rwanda or South Africa. The systems that have been oppressing have somewhat materially changed. But in countries where there's been atrocities and those institutions continue to remain in place, are there justice mechanisms outside the purview of institutions that can still provide healing? What do you think those might look like? And how do we ensure that victims in those situations also have some form of healing, even if the governments or the institutions have remained the same?
Well, they may not get justice in their own countries if the government does not have the will to have it investigated, or if the government is involved. Kenya is a good example. And that's why I'm so supportive of the mechanisms that have been set up since the Human Rights Council was established. And you can understand why the Russian ambassador is complaining that we've gone too far. So the mechanisms would examine, under the UPR scrutiny, that country that you're mentioning. They will get feedback from the NGOs, civilian societies in that country, all over the world, and from all the UN agencies. It feeds into that process. And states rush to come and give their side of the story or defend themselves. And the recommendations would be, you have to prosecute these perpetrators. There has to be delivery of justice in your country. So it's states telling each other. So they do react, they come and defend themselves in the UPR process. See, there's scope for you to tell people about that process when you think governments tell their public, oh, we are about to be scrutinized at the UN for our human rights record. They'd rather keep that information away from you. But you know about it and you inform civil society actors.
Please join me again in thanking Judge Pillay.
Thank you very much. Really, I have to clap for you because of your questions. What a great audience you are. Thank you. Thank you for your questions.